Whoa. How the hell do you jump to that conclusion? Court does call the case people of the state of Michigan versus Darren Wilson.
This case opens at full speed, and that alone tells you everything about the tension already sitting in this courtroom. Before any evidence is discussed, before any witness takes the stand, we immediately hear a judge stopping defense counsel. Mid-argument. That is never a casual moment. When a judge interrupts like this, it signals that something being argued is either legally unsound, poorly framed, or pushing far beyond what the law allows. This case revolves around a core procedural issue: whether a judge who signs search warrants can later preside over a preliminary examination. That might sound technical, but it matters deeply. The defense is trying to suggest bias, not because of what the judge said, but because of what the judge did earlier in the case. The prosecution, on the other hand, argues this is routine, lawful, and well settled. What makes this moment explosive is not just a legal question, but the confidence with which defense counsel presents it and the immediate resistance from the bench. From the very first seconds, this becomes less about paperwork and more about credibility, precision, and whether counsel is stretching case law beyond recognition. The audience should already be asking, is this a legitimate constitutional safeguard, or a strategic attempt to remove a judge who won't be favorable?
And good afternoon, Your Honor. Good afternoon to your fine staff. May it please the most honorable court. Edward Martell, P85051. On behalf of Darren Dwayne Wilson, sir, please stand and give your full and complete name for the record.
Darren Dwayne Wilson. Thank you.
Your Honor, today is the date and time scheduled for a preliminary exam. I believe that Mr. Martell would like to start us off by motioning for Your Honor to recuse himself from this case.
Judge, if I may, very briefly.
Go on.
Thank you, Judge. And certainly, Judge, I got much respect for this honorable court. Been before this court a number of times, Judge. But the court rule is clear, Judge, that a examination must be conducted by a neutral and detached magistrate, Judge. In this particular case, and just for a little bit of context, for Your Honor, this is a case where there's already a co-defendant, where an examination has been held, where the testimony has been taken, where the victim or complainant absolutely identifies a mixed race, ethnicity, light-skinned male, certainly not my client who's dark brown skin with barrel rolls. Judge, notwithstanding saying, Your Honor, the sole basis that the people intend to introduce quote unquote identity is through the search warrants and the subsequent evidence that was purportedly obtained thereafter, Judge. I say that all to say that, Judge.
I don't know what case you're talking about. Who's the co-defendant?
You didn't preside over that. I could make the argument a lot more.
I did not preside over it?
No. So the argument that counsel is attempting to.
Well, then I'll let him finish, because I don't know. It did not even begin to ring a bell with me.
It shouldn't.
But if I can just streamline it, Judge. In brief, Your Honor was presented ex parte with two search warrants in this particular case. Ultimately, these two search warrants, there was information heard, there was a search warrant, there was probable cause found, there was search warrant signed. Judge, we now come before you for a separate analysis of whether there's probable cause in this case, but Your Honor, pursuant to People Be Real, which is 391-124, Judge, it certainly cannot be neutral and detached when Your Honor respectfully has already found probable cause in this case, and specifically the case law says.
Whoa. How the hell do you jump to that conclusion? Because the probable cause that's determined from a search warrant is based upon that evidence that is presented to me in the form of an affidavit on that search warrant. That's going to have no bearing whatsoever on what testimony I hear or don't hear in this case. So I don't even know how you get to that conclusion. But I'll let you continue, because I think
This is a critical clarification from Judge Simpson, and it cuts straight through the defense's theory. The judge is drawing a bright legal line between probable cause for a search warrant and probable cause at a preliminary examination. Those are not the same thing. A search warrant is based solely on the four corners of an affidavit, written allegations, sworn, but not tested through cross-examination. A preliminary exam, by contrast, is adversarial. Witnesses testify, credibility is assessed, and evidence is challenged in real time. The defense is attempting to collapse those two stages into one, arguing that because the judge previously found probable cause on paper, neutrality is somehow compromised. The judge is firmly rejecting that logic. From a legal standpoint, this matters because if this argument were accepted broadly, judges would be disqualified from countless cases simply for doing routine judicial work. The frustration you hear isn't emotional, it's institutional. The court is protecting the structure of the criminal justice system itself. Viewers should note how methodical this response is. No shouting, no personal attack, just a clean explanation of why the argument does not connect legally.
Go ahead.
Thank you, Judge. And Judge, just certainly to preserve the record, certainly I don't want to come back on a quash or an appeal or even a remand, Judge, but the case law is clear. It says if the defendant requests a magistrate other than the magistrate who has already heard ex parte witnesses, such as the request should not be or should be regarded as reasonable and reasonable efforts exerted towards compliance, Judge.
What ex parte witnesses did I hear from?
Judge, Your Honor signed both of the search warrants in this particular matter, certainly testified.
But that says I've heard from witnesses. I've not heard from any witnesses.
Judge, so if it's your
Does
position,
that case clearly apply to search warrants?
that it's not limited to search warrants. But if
That isn't what I asked you, Mr. Martel.
yes, Judge.
Is that applicable? I could certainly see a circumstance where I would have heard, like what you started out with, which doesn't seem to be true, that I heard something and then there would be a request that I not hear it because I've heard the witnesses or testimony. And so in that circumstance, there would be a much different analysis. But now you're trying to cite a case, apply it to something that I don't think that applies to.
Judge, what I'm
Just by the very words that you said. And certainly you show me that it says that a judge that has, or a magistrate that has signed a search warrant should not then hear the preliminary examination where they made a finding.
Judge, specifically, this relates to an arrest warrant, not a search warrant. However, if it's the position of the court that Your Honor has heard no testimony, sworn testimony or otherwise, then I guess our request would be moot. But
I have read, so that we're clear, because you're playing fast and loose with words. So that it's clear, I would have read the search warrant. I don't recall receiving any testimony at all regarding that search warrant because I typically don't. I make a determination if there's probable cause contained within the four corners of that document, swear the individual in, sign off on the search warrant. It's really as simple as that. So if you show me a case, Mr. Martel, that says under those circumstances the court shouldn't hear it, then show me the case. Otherwise, you're wasting my time.
This is a warning shot. When a judge accuses counsel of playing fast and loose, it's not rhetorical flair, it's a professional rebuke. The court is signaling that accuracy matters more than advocacy. You can argue hard, but you cannot distort what cases actually say. At this point, the judge is still giving the defense an opportunity. Bring controlling authority or stop. This moment also introduces potential consequences, sanctions, written motions, even findings of frivolous conduct. For viewers unfamiliar with courtroom dynamics, understand this. Judges rarely escalate unless they believe the integrity of the process is being tested. The defense is no longer arguing uphill. They are arguing under scrutiny.
Judge, so acknowledged, I would say that Burrell is applicable. And I would also humbly submit, Judge, it's the position of the court that anything outside the four corners of the exam transcript has been analyzed or sworn to, then it would certainly fall.
Then you're going to need to file a motion. So I can, if it doesn't bear out, I can find it frivolous and I'm going to adjourn this and then I can sanction. You need to file a written motion. How long is that going to take you?
Judge,
How long is that going to take you?
Judge, certainly.
How long is that going to take you? If you cannot answer that question, then I will take a recess. I will give you time to think about that. And then I will come back and I need your time frame for how soon you can file the motion. In fact, why don't we just
Judge,
do
we're
that?
prepared to proceed.
Why don't we just do that? You can take him back. Court's going to stand in recess.
All right.
Court recalls case of the People versus Darren Wilson.
And good afternoon once again, Your Honor. Good afternoon to your fine staff. May it please the most honorable court. Edward Martell, P 85051, on behalf of Darren Dwayne Wilson. State your name once again for the record.
Have a seat. So, Mr. Martell, you know, I'm a bit concerned. I just take what people give me. But I'm just going to say this. You lied to me at the very beginning of your argument. I went back, had my staff go back. You said that I held a preliminary examination on the co-defendant.
This is the emotional apex of the hearing. Accusing an attorney of lying on the record is severe. Judges choose words carefully, and this accusation reframes the entire proceeding. What was once a legal disagreement becomes a credibility crisis. The judge explains that he verified the claim independently and found it false. That matters. This isn't heat of the moment anger. It's a conclusion based on review. For the audience, this raised an unavoidable question. Was this a genuine mistake or a strategic exaggeration? Either way, the damage is real. Once credibility erodes, every subsequent argument is viewed skeptically. This is also where the power imbalance becomes visible. The judge controls the record, the schedule, and the consequences.
I couldn't recall it, but it's not true. That was an absolute falsehood and misrepresentation to this court. Ms. Hughes then points that out, but I'm still not sure. On the break, I go back, have my staff look it up, which was some doing, but if the case that you're referring to as a co-defendant is Christopher Harrison, that case number for reference is 24F22251, our case number. That is not the circuit court case number. I didn't handle that exam. Judge Barr handled that exam. So your initial argument regarding recusal started with and I hate using the word, but it's true. It started with a lie. Then, Mr. Martell, you continued with your lie regarding the import of the case of People versus Burrell, which you cite one portion of it about a magistrate who takes testimony and does that. And that's why I went through exactly what this court does regarding search warrants. And then you cite a portion of that, and I think intentionally skipped over the first part of that paragraph to mislead this court. And I'll tell you what it says. It says, whereas here, an affidavit presented to a magistrate was in conclusory form, which I'm sure those search warrants were, and did not state any of the underlying or operative fact, and no witnesses were examined, which they weren't, we can perceive no prejudice to the accused in having the magistrate who issued the arrest warrant, which is different.
This is the legal knockout. Judge Simpson doesn't just reject the defense argument. He reads the case law aloud and explains what was omitted. That's significant. Courts expect attorneys to present precedent honestly, including unfavorable language. Skipping operative portions is viewed as misleading. The cited case explicitly states there is no prejudice when no testimony was heard, directly contradicting the defense's position. At this point, the legal issue is effectively resolved. What remains is procedural cleanup and accountability.
Preside at a preliminary examination.
If I may.
If it's not going to be a lie, go for it.
Judge, respectfully,
No, you lied to me.
Okay, if I may, Judge, very briefly, I think the record will reflect that when I cited or spoke about a preliminary examination, I didn't speak directly as to this court having held it, but it having been previously held. I was not present at that particular examination. However, Judge, certainly I would make no false representations as to who held it or who didn't hold it. I think I just provided that for context.
You want me to play it back?
Judge, I certainly do not, but
You want me to play it back?
Judge, I certainly, if Your Honor, some other time wants to, that's fine.
No, if you're gonna sit up here and tell me you didn't lie to me, you want me to play it back?
Judge, then I stand corrected, Judge, but I certainly intend to make no misrepresentations to the context. The main argument is what it is. And certainly Your Honor is not barred from presiding over this exam. But again, and I've spoken with my client in the basis of just preserving the record and putting forth this argument, certainly mean no disrespect, harassment, or delay to the people. Judge, we're prepared to proceed. If Your Honor intends to deny, that's fine. Again, we're prepared.
I don't know what your motion is because everything that is presented to me is not it. Ms. Hughes, do people have anything to say regarding this?
I have quite the record to make regarding the one thing that I absolutely have to say, even though I think this argument is clear and where this situation is headed is clear, but the thing that needs to be abundantly clear, I do have a lot to say about the law and I do have my own cases to cite, but if Your Honor doesn't need those, I'll set that aside. But the thing that needs to be said is the search warrants that Your Honor reviewed are what led to the pertinent testimony today. They did not include the pertinent testimony that would be heard today. Your Honor signed off on search warrants that include facts that frankly are not being contested. The defense is not contesting that these crimes occur. They are contesting the defendant's identity. The search warrants led to evidence of the defendant's identity, facts that Your Honor has never heard before, which is where we're about to go. But frankly, the law that I'm choosing not, and maybe I just need to, the law is actually clear that a judge who has reviewed and approved a search warrant, even on facts that they will later hear, that is okay, that procedure is okay. And specifically, I turn to People v. Cameron, which is an unpublished case of the Court of Appeals from 2013, and Cameron is Cameron. And in that case, not only did the judge review and approve the search warrant, but that judge went on to be the trial judge, a bench trial judge. And the Court of Appeals said in that case, so the issue that went up to the Court of Appeals was the defendant was claiming that his trial attorney was ineffective by not trying to recuse that judge. And the Court of Appeals said, failing to advance a meritless argument or raise a futile objection does not constitute ineffective assistance of counsel.
The prosecutor reinforces what the judge has already established. Michigan law permits judges to approve search warrants and later preside, even at trial. This isn't a gray area. The prosecutor's restraint here is strategic. Rather than inflaming the situation, she grounds the argument in appellate authority. That contrast matters. While defense counsel argues preservation of the record, the prosecution frames the motion as legally futile.
That is what the Court of Appeals said about trying to recuse a judge who has previously reviewed a search warrant. The other case that is specifically on point is a much older case. It's from 1971. It's People v. Pitchford, 3-3 Mich. Act 299, 1971. In that case, the defendant actually, at the preliminary exam, wanted to attack the search warrant that the judge approved. And that judge that had approved the search warrant at issue went on to be the preliminary examination judge. Mind you, on appeal, it wasn't that exact issue. It was more of a statutory interpretation issue that went up on appeal. But the Court of Appeals in that case said the statutory interpretation would have led to the same procedure, that the search warrant judge would have become the preliminary exam judge, and then they affirmed and the case went back down for exam. But in that case, we don't even have a case where the defense is trying to say that Your Honor inappropriately approved the search warrant. And we don't have a case where the defendant is even trying to contest any of the facts that were in the search warrant. Sorry, from having nothing to say, I always have a lot.
No, that's fine. Anything else, Mr.
Judge, just very
Martell?
briefly, and I certainly respect this.
Because I'm going to tell you that, quite frankly, Mr. Martell, one may have to convince me why you have not, only in terms of your misleading of this court, attempted to try to have this judge recuse for the purpose of forum shopping.
Absolutely.
Because, oh, I think so. Because originally I had to step into this case, and I can tell you, you probably weren't necessarily real excited about it.
Forum shopping is one of the most serious accusations a judge can level procedurally. It suggests the defense is not seeking fairness, but advantage. Once that allegation is voiced, the court's tolerance drops sharply. Even if unproven, the mere suggestion reshapes the narrative. The judge is now evaluating motive, not just law.
But that's the way that the system works here. And so I think you're continuing on with that. And because there's no other reason, I think, to try to bring this frivolous argument.
Judge, respectfully, I certainly enjoy practicing before Your Honor, and I certainly had no intent to misspeak this or in fact, before the exam or the transcript thereafter. As far as I don't believe any misrepresentations were made to this honorable court, Judge. I stand firm on my word. At the end of the day, I think there's a basis for our argument to put forth if it's the position of the court that it's not certainly, Your Honor. We will move forward with your denial, and we're prepared for.
I have not ruled. You will hear my ruling loud and clear.
Yes,
but do
Judge.
not presume that I'm going to deny it. Before I stepped off the bench, I asked, and I think properly so, your motion should be in writing. How long will that take you to do? If you won't answer me, then I will set the time frame.
2 weeks, please, and thank you, Judge.
Defendant's motion to recuse would need to be filed by December 10th. Prosecutor will respond by December 20th. I will hear the motion on December 26th. This exam is moved to December 26th, 2024.
Despite everything, the court still follows procedure meticulously. Deadlines are set. Responses are scheduled. The judge separates frustration from process. That distinction is crucial. Even when counsel is criticized, defendants retain procedural rights. This reinforces the legitimacy of the ruling.
At 12 noon.
Thank you, Judge.
Just for scheduling.
Yes, go ahead. No, that's fine.
I am not available on December 26th. I am
That's-
the person that will be filing the response. I would love to be the person to litigate it as well.
Understood. Then preliminary examination, since this is not of the people's doing, and the defendant, by raising it as well as before, has waived any time requirements, the preliminary examination as well as hearing on the motion will be January 2nd
Thank you, Your Honor.
at 12 noon. 12 noon. Thank you. Mine continue.
This hearing ends with structure restored. The court denies nothing prematurely, sets deadlines, and moves the case forward. The attempted recusal fails not because the defense raised concerns, but because those concerns did not match the law or the facts. Judge Simpson makes clear that signing a search warrant does not compromise neutrality, especially when no testimony was heard. The broader takeaway is simple but powerful. Credibility matters as much as case law. When arguments stretch precedent or misstate facts, they collapse under scrutiny. If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.